What happens if you've got a defendant who won't actually come into court, whether that's for the trial or when they're being sentenced? What can you do about that? Just thought I'd do a little bit of a brief overview. Generally speaking, while you have a right to attend any criminal proceedings against you, obviously, um, you're not obliged to. Okay? And the procedure basically is you are given every opportunity to attend court, but if you just waive that opportunity, um, then they can proceed in your absence. So, even if it's something like, your first appearance at court, it's what we call arraignment. Um, that's where you plead guilty or not guilty, we set all the directions. And just somebody's not cooperating, there has to be an inquiry. The court will say, well, why aren't they here? Have they been told? But if they are represented or they're eligible to be represented, um, and they have been told that, look, you have a right to attend court, and they are warned that proceedings can go ahead in their absence, then the court can actually just do that. And if you just don't cooperate at all, they just stick in a not guilty plea and just proceed with everything. Same with the trial. If you want, you can just stay in the cells and not come up, not give evidence, not do anything. That obviously can be held against you because there's all the, you have the right to remain silent. But if you don't give an explanation, we can use that to infer guilt. Although you can't convict just on somebody not giving evidence, either answering questions to the police or when they're in court. But yeah, the trial can go ahead in your absence, and often they do. But what if it's like you're convicted and it's sentencing? I mean, people have said this thing about they should be there because we have what we call victim impact statements now, where the people affected by the crime can sort of have their little say and they're read out. Now, actually, they're technically not meant to have any effect on like sentence or anything like that. It's just basically giving people an opportunity to sort of say what they think. And the argument is, well, yeah, the convicted person should have to listen to that. But currently, there's no sort of way of forcing anybody to do it. A refusal to come up, it can be reflected in the sentence. The judge can say, well, you've shown further disrespect to the victims, and I'm going to add something onto that. On a minor offence, maybe that might be a little bit of pressure, but if somebody's facing a life sentence, what can you do about it? There are talk about legislation allowing effectively the security people to drag somebody into court, but what if they kick off? I mean, the irony there is, if you come into court and you do kick off, the punishment is you get sent back into the cells. So it's a bit of a catch-22, really. I mean, I suppose, in terms of, how can you motivate somebody to do that? You could sort of say, well, your sentence, I'm not going to sentence you until you agree to come into court and sit there quietly. Then, you can just stay in the cells, clocking up time that's not going to count. Maybe something like that. But it is a really tricky one. But like I say, yeah, currently there's absolutely no obligation whatsoever to attend your own hearing, and they can't force you. Anyway, if you found that useful or interesting, please consider clicking the like button, subscribing, sharing, all that sort of thing.